I was completely wrong about the criminal charges against Connecticut State Trooper Sergeant Bryan Fahey.
You are. Right now. You spit in my face. My property right now. You're going to jail now. Get off my property right now. Look at this. He's spitting my face.
I think it's stretching to suggest that spitting is assault under Connecticut law. What the spitting does do is it enhances the threatening nature of Fahey's conduct.
This is the biggest mistake you ever made.
Especially because it occurred while he was armed.
Look at the gun in his hand.
Hey, what's up guys? Long Island Audit here, back again with another video. I recently came across a video posted by the YouTube channel Southern Drawl Law, which is run by James White, a criminal defense attorney and former prosecutor and law enforcement officer. He did an absolutely brilliant job with his legal analysis, breaking down my encounter with Sergeant Bryan Fahey. So much so that after watching his video, I realized how wrong I was about the criminal charges against Fahey. If you care about this incident at all, this is a must watch. Please hit the like button and share this video because the world needs to see this invaluable information. Let's get into it.
So first thing, I think it's pretty obvious and pretty well widely accepted that there's an implied license where there's no communication from the homeowner that there is no trespassing sign on the property. That journalists do it all the time. I mean, hell, if you watch Jody Barr, that cat will sit in your kitchen and eat your cereal out of the box. Like he's all up in your business. He don't care where you are. So these investigative journalists really don't really intimidate. And that's one of the things that I love about Sean, because a lot of people will call him an instigator. But the truth is, everything that he does is conducting himself like a journalist. The only difference is that the things that he does, like the billboard truck and things like that, are things you could never do if you had a boss. So that's where the independent part comes in, right? Because even Jody Barr or Dave Biscobing is probably not going to get cleared by corporate to go put a billboard truck in somebody's neighborhood, right? So that's the freedom that comes along with being an independent journalist. And I don't think there's any argument to be made that he broke the law by knocking on the door. There is an accepted implied license allowing members of the public to approach a residence for lawful purposes, like knocking on the door, ringing the doorbell. Sean very clearly exercised that right. I think his cameraman was off 10 to 15, 20 feet in the yard. It's hard to tell because of the camera. And Sean did something really important that will come in later, which is that he rang the doorbell and stepped off the porch, meaning he wasn't looking for a confrontation. If he was looking for a confrontation, he would have stayed up on the porch and been face to face with the man in his doorway. And that would have been an enormous mistake. But he didn't do that. He intentionally stepped off the front porch to avoid a confrontation, which I think kills a lot of the arguments in favor of any criminal charge relating to him even being on the porch in the first place.
Oh, I'm currently being recorded, his Ring camera said.
Can I help you?
Hey, Sergeant Fahey, how are you?
You gotta get off my property.
Now, under Connecticut law, Fahey would have the ability to use reasonable force to eject a trespasser. Now, remember that the status changes, basically. You're not a trespasser due to the implied license when you approach the door, but the second that he tells you, get off my property, that transforms Sean Paul into a trespasser if he is not leaving. But you can't see the cameraman move, but you hear about 5 seconds later, Sean give the cameraman the command to let's go, come with me, whatever he says. Sean says in his commentary that he is already moving back, and we can't see that. We have no reason not to believe that. Had Fahey already had a gun in his hand when he answered the door, I think the analysis in this case would be a little bit different, but obviously, by the time Fahey goes back inside and grabs a gun and comes back on the phone with 911, his right to use an elevated level of force, like a threat of deadly force, is pretty much extinguished because Sean is no longer on the curtilage of his home.
I just want to say here that I noticed this when I first watched the video, but I must have overlooked it when I was doing my commentary. But it's obvious here that where Sean is by the time Fahey actually makes it out with the gun, he's not even actually on his sole property anymore. It looks like he's, God, maybe several hundred feet away from the house, and it looks like he's just on this common driveway that is jointly owned. We don't even know whether Fahey has the actual legal authority to eject him from this property itself. Maybe he does, maybe he doesn't. But the point is, his level of force that he's reasonably allowed to use is almost nothing at this point. It certainly doesn't involve a gun and spitting and all the things you're getting ready to see.
Property. Well, do you see me not moving?
All the way to the cul-de-sac.
Calm down.
Get off
Get
my
that
property.
Get that gun out of your hand. property. Get that gun
I'm
out
a
of your hand, you
goddamn
psycho.
Connecticut state trooper.
I don't care who you
are. Trespassing
I don't
on
care
my
who you are.
fucking
I don't
property.
care who you
Get
are.
off my
I don't
property.
care who you are.
Right now.
You spit in my
Get off
face.
my property
You're
right
going
now.
to jail now.
Get
Look
off
at
my
this.
property
Look
right
at
now.
this.
Now, this is where I would disagree with. I watched a live stream that Sean had where he had a police officer from Texas, I think, on his live stream, and he had an attorney that I think had previously represented him in some Connecticut litigation. I think it's stretching to suggest that spitting is assault under Connecticut law. And the reason I say that is because I actually think that in this particular case, the police officers got that right. If you look at Connecticut law, it does in fact require, for the purposes of assault, physical injury. And you don't need it. And I'll explain why. There's other laws that could be implicated here that cover this conduct. You don't need to make this long argument about how getting spit in your face is an assault. I think it's absolutely disgusting. I think that the way that Sean conducted himself and the composure that he showed in the face of getting spit in his mouth was incredible, the restraint that he showed, but I don't believe that it qualifies under Connecticut law as assault. It clearly says physical injury. If Sean had contracted AIDS or hepatitis as a result of having mouth spit and he had followed up with a doctor, sure, that could be charged later. But the idea that you immediately assume physical injury simply because somebody spits on you, and I don't mean to say simply because to minimize the gravity of being spat upon, but the point is it just does not have statutory footing and you don't need it. That's why the spitting, in my opinion, is not an actual assault under Connecticut law. What the spitting does do is it enhances the threatening nature of Fahey's conduct, especially because it occurred while he was armed and during a continually aggressive confrontation that was not reasonable under the circumstances. And that's why it opens the door to a law that does actually fit, and that is threatening in the second and first degree under Connecticut law. Threatening in the second degree involves intentionally placing another person in fear of imminent serious physical injury through physical threat or menacing behavior. Okay, so that's where we start. There's no argument really to be made that disorderly conduct and breach of the peace are present at the time of the spitting or in the yard or anything like that. What you have to remember that disorderly conduct and breach of the peace are traditionally public offenses. So I don't think you can make the argument that when you're standing on somebody's porch or in their yard and they're trying to eject you as a trespasser, or even on a private road that is labeled as private road, that you can invoke sort of the danger to the public or the public element. A public element is an essential element of a breach of the peace. It's specifically enumerated statutorily for breach of the peace, but it's also in case law been adjudicated as being necessary for disorderly conduct. In fact, in Tennessee, our statute says in a public place. So it doesn't say that in Connecticut statute, but the courts have held that there's a public element. There has to be an exposure or at least a risk to somebody else in general public in order for disorderly conduct to be in play. So the argument that Fahey's conduct qualifies as a breach of the peace or disorderly conduct, for the most part, is null and void, in my opinion. I don't think it fits the factual circumstances. But again, you don't need assault, you don't need disorderly conduct, and you don't need breach of the peace in order for this to work in Sean Paul's favor. So let's walk through what you do actually have here that's pretty clear cut so that we can forget the argument that we need to stretch the facts and circumstances to make particular things work. Those offenses are misdemeanors. Threatening in the first degree is a felony, and that's actually what happened here. If you look at the threatening statute in Connecticut, the one to look at is threatening second degree. So let me kind of break that down for a second here. Threatening in the second degree involves intentionally placing another person in fear of imminent serious physical injury through physical threat or menacing behavior. Had Fahey walked out on his porch or even down and stood in his yard with a gun at his side, I think that's fine. But pursuing Sean Paul as he's retreating from the home, making it obvious that he is, to the extent he ever was a threat, is no longer a threat, to come up to him with an unholstered weapon down at your side on the phone with 911, screaming and acting like a complete animal the way Fahey does. He absolutely placed Sean, or any reasonable person, when another person has a gun, not in a holster, by the way, and that matters. We'll talk about that more in a minute. Not in a holster, down by their side. You know, all it takes is now an invitation for a physical confrontation in order for that to become a deadly force scenario. And when you combine that with the sort of close proximity pursuit that Fahey conducted of Sean Paul as he was trying to retreat, and then the intentional body checking, and then the spitting in the face, that's absolutely placing any reasonable person in fear that, hey, this is going to turn into an actual physical fight, and now there's a gun involved. There's really no argument that this is not threatening at a minimum in a second degree. But threatening in the first degree starts with the baseline of threatening in the second degree, which we've already satisfied the elements of based on Fahey's conduct. And if a firearm or another deadly weapon is used, displayed, or implied as a threat during an encounter, then you elevate that from second degree to first degree threatening, and that is a D felony under Connecticut law. So, Fahey's conduct meets both thresholds. He was visibly armed. He intentionally closed the distance to within inches of Reyes. He spat in his face. He body checked him, and he continually escalated a verbal confrontation while holding an unholstered weapon and announcing himself as a Connecticut state trooper without the privilege of the self-defense that he would have been afforded back on his porch, right? All of that matters because it takes him out of the privilege of a law enforcement officer. Now, if this was in Groton or Groton or however the hell you say it, it would be different if Fahey was not a Connecticut state trooper, but a Connecticut state trooper has statewide jurisdiction. So him announcing himself absolutely elevated himself to acting under the color of law. We'll talk about that more in a couple minutes, but this is a situation where he actually committed a much more serious offense than the ones the attorney was arguing for in the initial sort of backdrop of what happened here. Now, I don't blame him for that because we're all emotionally charged, right? These are people that he cares about. He's just sort of grasping at straws. But the problem is if you make the argument that Fahey is guilty of breach of the peace and disorderly conduct, it at least shifts some scrutiny to Sean Paul because he's doing, you know, while not nearly as egregious, he's sort of mutually involved in some of this stuff. And so I think it's bad for your client if you're making an argument that, you know, it's okay for Fahey's lawn to be public for the purposes of breach of the peace and disorderly conduct when those charges really don't carry much of a penalty at all. And it sort of places scrutiny unnecessarily on Sean Paul when the truth is there are other arguments to be made. So let's continue and we'll finish up our other arguments to be made as it relates to these things.
Passing on my property.
That doesn't matter. You can't break the law.
Kill me.
I didn't.
You threatened to kill me online.
Right. No, I did not. You're a liar.
Right now.
You are a liar.
Right now.
Look, see the big beautiful billboard truck? It's all being recorded.
I don't care.
It's all being. I know you don't care. Because you don't face any consequences.
Get off my property right now.
There's the argument made that Fahey committed defamation by saying that Sean Paul had threatened him online. Defamation requires publication to a third party who is not the subject of the statement, and it can't be privileged, okay? Statements to 911 operators are generally privileged, and statements to the police in the process of reporting what you believe to be a crime are generally privileged and not subject to action under defamation law. The only person that he's published this to is Sean and at most the 911 dispatcher. This is really not actionable or even considerable under a defamation law or for the purposes of a defamation tort.
This is the biggest mistake you ever made.
No, it's not.
This is the biggest mistake you ever made.
No,
Get
it's
off
not.
my property right now.
It's not the biggest mistake.
Get off my property right
it's
now.
It's not the biggest mistake.
Get off
you
my
spit in my face.
I didn't spit in your face.
You disgusting.
I was spitting on you.
The public element of disorderly conduct, in my opinion, is not present back in the yard. But watch this. Watch after the spitting happens. So, in my opinion, you lose the privilege of self-defense with chasing him down, bringing a gun out, all that stuff. So we have, in my opinion, threatening second and threatening first because of the introduction to the firearm, right? All at the same time, and the spitting and all the things, right? Under the totality of the circumstances. But watch what happens here at the end. For about 50 seconds, Fahey is continuously crossing back and forth over a public sidewalk at the end of this private driveway. And Sean Paul is standing in public. Now, Connecticut does have a duty to retreat, but you have one armed guy and you have one guy acting like a complete lunatic with an unholstered gun. There is a scenario where a person sort of rolling up on the scene, not being a police officer, not knowing what's going on, could have felt like Reyes was in potential danger of death or serious bodily injury and could have shot Fahey. And I think a jury might have acquitted them in that situation, because the duty to retreat only works if you have the time to do that. If you rolled up on this scene in that 50-second window where Fahey is very clearly in public and acting in such a menacing way while holding an unholstered weapon, I think it might have been reasonable for a third party to be like, we need to put some rounds in this guy before he kills this person. So that may not be, in my hypothetical, ultimately a legal justification for use of deadly force, but it certainly makes Fahey's conduct a breach of the peace and disorderly, because it's fighting words after he spit in his face and now he's actually in public. So again, you don't have to conflate the privacy of this guy's property in order to get to breach of peace and disorderly conduct. It just wasn't breach of peace and disorderly conduct back when they were on private property. But there's a full minute here where this guy's pacing back and forth and acting like a complete idiot while holding a gun and on the phone with 911, where all of those things could have elementally been met.
I'm gotta go. What a crazy psychopath. He spit in my face. No, I'm an independent journalist. Get it right, buddy. Get it right. I never threatened. He says I threatened to kill him? Ooh, I knocked on your front door. I'll get that 911 call too, buddy. Look at this guy. I'm a Connecticut State Trooper. Come help me from the camera. Come help me from the guy asking me questions, please, before I shoot him. And I did. And I did. No, you spit in my face and you're going to jail. And you're going to jail. You're going to jail. You spit in my face and you're going to... It's all right here, buddy. Right here. It's all right here. It's all right here, buddy. Look at these guys. Look. Look. I'm not breaking any laws. I'm not doing anything. He just spit in my face.
Get over here.
Whoa, I didn't break any laws.
You in a second, okay?
For what? I haven't broken the law. No. But do you have reasonable articulable suspicion I committed a crime? What? What is it? What is it?
I got a call from a trooper.
That doesn't matter.
His face and there's a disturbance.
It doesn't matter. I'm a journalist. I knocked on the door and asked questions. No, I have no weapons on me.
You have weapons on you.
We have a camera of mass destruction. I'm putting my camera down.
Don't move. Don't move until I get backup units. You can put it away.
What's your name?
Officer Romansky, it says right here. Nope, just stay right here.
He pulled out a gun on me for knocking on the door?
No, you're on his property.
I'm allowed to go on his property and knock on the door. Yes, I am.
Okay.
Yeah. You got to learn the law, man.
No.
I'm a journalist. No, you got to learn the law.
Okay. Let's just back up.
I'm allowed to ask questions.
Sure.
I am.
So let me tell you why we're here.
What's wrong with you? I'm not doing anything. I have no weapons on me. I have nothing. You couldn't stop. He has the weapon.
Okay. Now let me explain something to you.
Make sure no weapons. He has the weapon.
Recording. Okay. So here's the deal. So here's the disconnect here. Here's the difference. So we get a call from him. He calls 911. Hold on.
I'm not going to speak. I'm letting you speak.
Okay. When you call 911 and say you're
in a disturbance
with somebody, we come code 3, like my lights were on.
You wouldn't do this for a citizen.
Yes, I would.
No, you wouldn't. You're doing it because he's a state trooper.
No.
That's why. You're doing it because he's a state trooper.
Okay. We do it for citizens every single day.
Okay? Not like this.
Yes. 100% all the time. If we think there's an active disturbance, then we respond code 3, which means lights and sirens, and we're in an emergency response.
Do you see the spit on my face?
I don't.
You don't see the spit on my face? Well, I have it on camera.
Okay.
He spit in my face. I want him arrested. Okay. He spit in my face.
All right.
On camera.
Okay.
I want you to lock him up. He spit in my face. You understand that?
Okay.
If I spit in your face, what would happen to me?
Okay. Here, listen. Let's just.
I knocked on a door and he spit in my face. You can't do that.
Okay. I got what you're saying. Let's just take a step.
There's spit all over. I'm gonna go get DNA test on his spit so you can see it.
Go do what you gotta do. Let's find out what happened. The whole story.
All right, I'm gonna tell you really quick what happened. Okay?
No, tell me. Take time.
Okay.
Now, why I think that Sean was charged with voyeurism and why he potentially opened himself up to that, although I don't think it's an appropriate charge, I actually have a little bit of a conspiracy theory as to why he was charged with voyeurism. So the elements of voyeurism with malice under Connecticut law, this is a CGS 53A 189. AA1. So it's a Class D felony when all the following are proven beyond reasonable doubt: that the defendant photographed, filmed, videotaped, or otherwise recorded the image of another person, knowingly, that they did so knowing what they were doing, that they had a malice, which basically means that they're going to cause pain or distress or embarrassment without consent, and they did it to something that is not in plain view where there was a reasonable expectation of privacy. So when Sean Paul walks up to the door, he rings the doorbell and immediately steps off. Again, I'm glad he did it because I think he's doing it to avoid confrontation, but it also insulates him from any claim that there was voyeurism. And I think it's obvious that a critical understanding of the statute and a critical analysis of the statute, that this arrest lacked probable cause. But the reason I think they did it is because Sean was so traumatized by being spat upon that he pushed these officers to charge something. And except for limited circumstances, you can't make a warrantless arrest for a misdemeanor that didn't occur in your presence in Connecticut. There's like an immediacy clause, and there's a couple things going on. These officers came well after the confrontation was over. Sure, there was evidence on tape, but I don't think that this situation would have qualified for an arrest for a misdemeanor that didn't occur in their presence. And so I believe that they arrested Sean for two reasons. One, I think that if they were going to arrest somebody, it was going to be him. They weren't going to arrest Fahey. And so they arrested him for a felony because they couldn't arrest for a misdemeanor that didn't occur in their presence. And two, that is abuse of process, and it sets Fahey up to go ask for a protective order because now Sean has these pending charges. Now, we all know they'll probably be dismissed, but they're pending right now, which set Fahey up to at least file for an ex parte order, which are generally granted just based on the allegations and the circumstances. So Fahey goes in, he files an order of protection ex parte and says, hey, this guy showed up at my house, had a billboard truck, he was threatening me, he's threatened to kill me in the past. Again, all of that may be a lie, and it may be criminal for a false report or perjury under the court's rules, but it's not defamation because that stuff is privileged when you're making the arguments to a court or to the police. But I think that they arrested him so that they could set Fahey up to get a protective order and so that they could make an arrest on the scene, and they couldn't do it for a misdemeanor that didn't occur in their presence. So that's what I think, and the reason that he was arrested for voyeurism. And I think the main saving grace was that he just rung the doorbell and stepped off and was 20, 25 feet away from the actual porch when Fahey ultimately told him to leave. So in addition to the other offenses, we have reckless endangerment in the second degree under CGS 53A 64. It's a Class B misdemeanor, but it's where the defendant engaged in conduct, and that conduct created a risk of physical injury to another person. Reckless endangerment in the first degree, CGS 53A 63, is a Class A misdemeanor. Here's my argument for that. He intentionally walked inside. He intentionally got a gun. He took all of that into account, and yet he did not bring a holster. I can tell you as a former police officer, there's no chance that there wasn't a readily available off-duty, outside the waistband or inside the waistband holster that he could have put that firearm in. Holstered weapon says readiness. It says restraint. It says reasonable. An unholstered weapon, when you're a law enforcement officer down at your side and you understand that you may be starting a physical confrontation, that is reckless endangerment 100%. Not the spitting, which was what the focus of some of the legal analysis was. Yes, there's a stretch that spitting in someone's mouth, if you have bloodborne diseases or something like that, could create a risk of serious bodily injury. But the gun, unholstered, in conjunction with the menacing conduct, also creates reckless endangerment in the first degree under Connecticut law. So this is an easy win for Reyes without venturing into things that also invite scrutiny into his conduct. That's why reckless endangerment probably applies here for Fahey, but not for Reyes. Now, what does this mean as far as claims for Sean? Well, it's pretty obvious that Fahey acted here under color of law. He repeatedly identified himself as a Connecticut State Trooper during the incident. He used his authority, his badge status, and his firearm in confrontation. Keep in mind that when the police officer talking to Sean Paul, they're like, well, you came to a trooper's house, not you came to a citizen's house. They specifically said you came to a trooper, meaning that they considered their response to this call as a response to a fellow law enforcement officer. That, him acting under the color of law, opens the door for a 1983 claim for First Amendment retaliation because of the filming and the billboard and Fahey's conduct under the color of law. So that opens up the Connecticut State Police. But because of the fact that the Groton PD sort of cooked the books here and tried to help Fahey, instead of observing this objectively, they've opened themselves up for some federal lawsuits too. So in my opinion, here are the claims that are possible under these circumstances for Sean Paul. So you got First Amendment retaliation, because this is a clearly protected activity, filming a public official and engaging in speech on matters of public concern, right? First Amendment all day long. Fahey responded by pursuing him with a firearm, spitting in his face, repeatedly invoking his role as a state trooper, indicating that the conduct was motivated by animus towards Sean Paul's free speech. That sort of response to someone exercising their rights would chill a person of ordinary firmness in exercising that right. That's why it qualifies as a free speech retaliation, because there's a causal connection between the exercising of the right and the response and what an ordinary person would do in the face of such a response to exercising their rights. Most people don't have the backbone that Sean Paul Reyes has. They're not going to do this ever, ever, ever again. So that would chill an ordinary person. So that's why we got a First Amendment retaliation claim here on the state police. And then you have excessive use of force under color of law for state police. So you got a Fourth Amendment violation, in my opinion, too, because Fahey used unreasonable force under the circumstance. But as far as Groton PD is concerned, I believe they conspired with Fahey to abuse process, malicious prosecution, First Amendment retaliation on their part, too, because they really didn't arrest him until he kept pushing and kept criticizing their response. So that is First Amendment retaliation. It's also First Amendment retaliation because they repeatedly mentioned his approach to the door, his exercising his First Amendment rights with the billboard, all that stuff. All that was part of their calculus and the totality of the circumstances for them to make an arrest. So they, I think, are subject to retaliation claim as well under the First Amendment. But then we have an arrest for a felony that clearly lacks probable cause. All of those are Fourth Amendment claims that can be made under a 1983 lawsuit. And I think you got a Monell claim for Fahey because you got two previous incidents where they didn't do anything to him as a result of what he did in public at his job. And so you have maybe like the best and worst thing that could have ever happened to Sean Paul Reyes was this incident, because now he's got basically these two police departments on the hook as it relates to 1983 claims. He's like kryptonite to police departments. So in closing, the only thing I want to say that I think is sort of critical of Sean is that he's too smart to have not foreseen what Fahey would have done. And I think it would have been better if he had done some preliminary research as far as the GIS survey to figure out where the public and private parts of the property were. I think that it both helped him and hurt him that we have like a 500-foot or more driveway. I'm not sure that he knew that up front. I think it both helped him and hurt him because it made Fahey come so far out away from his home that it made his response unreasonable. But had he actually wanted to use deadly force, I think it put Sean in a really serious, threatening situation. And I think that he probably would not do that again. Again, I've never talked to him. I think what he does is great, and I fully support his work. That would just be my guess as to what his position would be on it now. The other thing is, I think that it might have been wiser to get this interaction on film and add it to your sort of catalog and highlight reel of Fahey and bring the billboard separate, because to the extent that with malice on the voyeurism was even possible, it was basically made possible by the fact that he brought that truck, because you couldn't even prove that Sean used his camera while he was up there. You really couldn't prove malice, but that truck makes it hard to make the argument that there wasn't some at least harmful or malicious intent, even though it may be protected speech. I think it would have been wiser to not have both of those things happening at the same time. So that would be my only criticism for Sean. And I think that based on the fact that he had two previous interactions with this guy, and this guy acted completely unhinged in public at the state police headquarters at work, that he should have expected that his conduct would have been worse at his own home. So those are really the only criticisms that I have of Sean. But again, it's easy to sit back here from the comfort of my chair in my office, not putting my life on the line for this kind of stuff, and make Monday morning quarterback judgments about what Sean did. Overall, 99.99%, I absolutely support what he did. Although I think that maybe if he'd had a second bite at the apple, he might not have done things the same way. But anyway, I just wanted to give my analysis. You guys have asked for it. That's where I land on it. I do think there are some serious issues. Those are my thoughts on it.
Absolutely brilliant. I typically give commentary on videos that I show on my channel that aren't mine. In this case, it wasn't necessary. I couldn't have done it any better. I always tell you guys I am not a legal scholar. Well, James White from Southern Draw Law is. He did an absolutely amazing job breaking down this entire interaction. Please go subscribe to his channel. Let him know in his comment section that LIA sent you, because he needs to get to 1 million subscribers ASAP. He did an amazing job. I know when to admit when I was wrong. I was wrong about the assault charge. I still think there's some wiggle room with attempted assault, but I was wrong about the breach of the peace, the disorderly conduct. What Fahey did was much worse. Sergeant Bryan Fahey's criminal actions meet the elements of threatening in the first degree, of felony, and reckless endangerment. These are the charges that I'm calling on the New London Judicial District State's Attorney Paul Narducci to prosecute Connecticut State Trooper Sergeant Bryan Fahey for. My actions do not meet the elements of voyeurism, criminal trespassing, and breach of the peace. This is a grave injustice. There needs to be accountability. Please take a moment and sign the petition. We have over 25,000 signatures to fire and prosecute Sergeant Bryan Fahey. I will leave a link where you can do so in the description below. I want to personally thank each and every one of you for your tremendous outpouring of support while I face this injustice. Your comments, emails, donations, letting other YouTube channels like Southern Draw Law know about this incident, it's been invaluable. I see your comments on the Groton Police Department Facebook page. If you haven't seen those, go check those out. Very funny. The AI images, Cop Tua. I see it all. I've been very busy with interviews and dealing with everything that's going on, filing complaints, FOIA requests. There's so much more to come. Waiting on the body camera footage, the 911 call logs. We are going to expose it all. But I see all of you, and I can only imagine how many of you have peacefully petitioned your grievances to your government, whether that's the Groton Police Department, the Connecticut State Police. I see the emails I'm being CC'd on. I see everything, okay? And I just want to say, I might not be able to get to each and every one of you, but I appreciate each and every one of you. Without you, none of this is possible. I would just be another statistic of the grave injustices that happen in the state of Connecticut. Excuse me, corrupting it. I got to get that right. They have all of the power. They have our tax money, unlimited funding, and they will go after me in every step of the way. Believe me, if they're doing this to me, that I have a platform, that I have support from hundreds of thousands of people across the world, it is absolutely mind-blowing to me that this injustice can occur. But I promise you, I will never stop fighting, no matter how hard it gets. Remember, divided we're weak, united we are strong. We, the people, can affect change together. We can hold our government accountable, but we need to stick together. Speaking of sticking together, on July 25th, 2025, next Friday is my arraignment, 1 week from today, and I'm calling on anyone in the Northeast area to come out and show support. I want to pack that courtroom with supporters, with patriots who believe in the Constitution, who believe in accountability. So if you can make it there, I know a lot of you already told me you are. I spoke to a gentleman outside of Staples today that says he was going. I just can't believe how big this platform is and how many people we reach, and we do it together. If you can make it next Friday, great. But everybody should be signing the petition with the link in the description. And if you can't make it, watch, because I will be live streaming if I have good service. If not, I will post it later on, but you can be there in spirit. You don't have to come make a 15-hour drive. You don't have to come fly over here. But if you're in the area and if you can make it and you feel the need to come, Please come. I would love to meet you. And we got to show the New London Judicial District. We got to show the Connecticut State Police, the Groton Police Department. We have to show them our power. I also promise you, when these baseless charges are dismissed, I will be filing a civil rights lawsuit against the Groton Police Department and Sergeant Bryan Fahey in the Connecticut State Police. I already have a civil rights lawsuit against him, so I'll just add it to the list. Again, thank you. I cannot say it enough. There aren't really any updates other than the fact that the state's attorney's office, run by Paul Narducci of the New London Judicial District, is investigating the matter on whether to bring additional charges. I don't know if that means against Sergeant Bryan Fahey or myself and my cameraman. That would seem pretty ridiculous, as we are already being charged with baseless charges. But who knows? Stay tuned to the channel or any of my social medias. I will be updating them as soon as I know more. As always, stay safe. God bless. I'll see you in the next one. Long Island Audit. Peace.